Let's see. Little private chat, Molly. All right, hold on. I'm just sending Molly a note. All right, I'm here. Hello, everyone. Thank you for joining me here today. We're going to talk some law today, multifamily law. So while we're letting everybody chime on in and join on in, tell me where you're from. Tell me where you're from. Who am I talking to? Who am I sharing my day with right now? Who am I going to teach the Corporate Transparency Act about? So, all right. Obviously, the government needs to keep tabs on you because they can't figure out where you live right now. So they had to create new legislation with new civil and criminal penalties if you fail to comply. Because Lord knows you're only one failure to disclose away from being a criminal in our judicial system. What do they say, like 300,000 new laws a year have passed? I taught this on my Monday night live call with all my students. And I love one of the guys on the call, one of the smartest guys, savvy investor, very intelligent. When I got done with my presentation, his response was, when were they going to tell us about this Corporate Transparency Act? I'm like, oh man, if he doesn't know, there are a lot of people that don't know. Okay, so let's talk about it. The biggest thing that you need to understand is that it was deemed unconstitutional by an Alabama district court judge back in March of this year. It's supposed to go into effect, the year of 2024, absolutely in 2025. But the problem was that this little disruptive organization called the National Small Business United, along with another guy I think his name is Isaac Wingles. Let me see if I get his name correct because it's a very interesting name and I don't want to I want to give him the credit. No, I was wrong. His name is Isaac Winkles. So you had that organization, the association, and one plaintiff sued Yellen, the Secretary of the Treasury, and said, you can't do this. You can't do this. I'll give you the exact reading. The court analyzed Congress's authority to enact the CTA under Congress's powers over foreign affairs and national security, the Commerce Clause, which should be a catch-all, and Congress's taxing power via the Necessary and Proper Clause. The court held that none of these constitutional provisions justified Congress's enactment of the CTA. Accordingly, the court entered a declaratory judgment that the CTA exceeded the Constitution's limitations on congressional power and enjoined, and it stopped, the government from enforcing the CTA against the named plaintiffs in that case, against the National Small Business United and Isaac Winkles. Those are the only two individual people, corporations, entities that do not have to comply with this law. But then what happened was the FinCEN, the organization within the Secretary, within the Treasury Department's purview that runs this particular legislation, they released a notice saying that they were going to file an appeal, and stating that as a result of that decision, the government is not currently enforcing the Corporate Transparency Act against the plaintiffs in that action, a category the government defined as the individual named plaintiff companies for which that individual is the beneficial owner or applicant, which are two new terms that you're going to need to understand, and I'll explain a little bit more about it later. The National Small Business Association and the members of that association. The government explained that those individuals and entities are not required to report beneficial ownership information to FinCEN at this time. Do we dodge the bullet? Not at all. Not at all. Under the district court's decision and the government's March 4th notice, only the individual plaintiff and the NSBA and approximately 65,000 members of the NSBA are relieved from reporting beneficial ownership information under the CTA. Currently, everyone else has to comply with CTA. And I can almost tell you, by the time the end of this year rolls around, they're probably going to have a decision, and there'll be some type of a rewriting of the law or overturning of the injunction against the Treasury Department. So when it first came out, you were all hearing about it, and it made a lot of sense. I'm going to fix my camera here for just 1 second. Usually you're not supposed to do that while you're on the camera, because that's when everything gets screwed up. That everybody was all up in arms. How do we do this? You're making us comply. Another law with civil and criminal penalties. How dare you? Well, the fact is that one person in one of the online boards that I was reading said, "Why does the government need to know this? They already know where I live." And the answer is, well, yeah, but they don't know how many entities that you have under your name in order to skirt the corporate veil or to remain anonymous. Those states. Garrett Sutton, who is I'm a client of his, and he was on my podcast. Great guy. And now you see his son, Ted Sutton, doing a lot of marketing for his company. The big claim to fame that he had was that you could come to my corporatedirect.com and become a anonymous Wyoming LLC or Nevada. Can't remember. And the answer is, holy cow. I just looked outside and it is pitch black. And it's only 3:00. I thought it was winter time. Wow, there must be a big storm coming through right now. So if I lose you, we'll catch up later. But anyway, let me talk to you a moment about what the Corporate Transparency Act is, what you're going to need to do, and when you're going to need to do it, most importantly. So let me pull up my notes here. So a little bit of a background. It was came about back in 2021 from the National Defense Authorization Act. The name of the act that came out of it was the Corporate Transparency Act. You'll hear it referred to as the CTA. And they passed their final rules back in September of 2022. Currently, it's the United States Department of Treasury that is running this, overseeing it. But the name of the entity within the Treasury is called the Financial Crimes Enforcement Network, or FinCEN. Now, should you do this? Absolutely. Can you imagine if you get cited by FinCEN for failure to comply with anything like this? It's as bad as being, sued by the SEC and then them deciding, well, you really don't have a case, so we'll let you go. But for the rest of your life, you're going to be known as the guy who got sued by the SEC. All right. So why did they do this? Well, the objectives of this legislation was to increase the transparency and then to close any legal and regulatory gaps in what was then considered the anti-money laundering terrorism network. And this is the way that they're going to do it. The whole idea is to protect the U.S. financial system from any illicit use by making it more difficult for bad actors like you to conceal your financial activities through LLCs and other type of ownership structures or opaque ownership structures i.e. Hunter Biden. And this is to protect all of us from the likes of him. And it's to prevent any corrupt actors, terrorists, proliferators, bad actors from hiding money or other property in the United States. I'm telling you, folks, when I was reading why they did this, I was thinking this is going to put Hunter Biden out of business. If they had this legislation enforced back 5 years ago, Joe Biden and his brother Jim would be in jail by now. So that is the purpose of why we do this. Okay, now what you have to, I'm going to use three different terms: reporters, beneficiaries, and applicants. These are the three entities, not like LLCs or S corps or C corps. These are the three entities that have been essentially created as the important entities we need to look out for because of this FinCEN rule. So when I say look out for, what I mean is you're going to decide which hat you wear in this legislation and then act accordingly. So let me give you some of the reporting when things have to be done. If you're an existing entity, like a limited liability company, I'm not talking, do you see how it's kind of confusing? I will call it applicants reporting companies and beneficiary ownership beneficiaries as entities, but then I'll also talk about the other guys as entities as well. Existing entities as of the effective date of January 1st, 2024, they have 1 year to report that they exist. So if you existed before January 1st, you got the whole of 2025. Now you might be thinking to yourself, well, wait a minute. I thought this thing is unconstitutional. I thought we don't have to do anything. Yeah, that's why nobody's doing anything. But you better get ready, because you're not one of those people. You're not one of those people in the, unless you might be a small business, a member of the Small Business United, and your name's not Isaac Winkles. So come the end of this year, for any entity you started before January 1st, you're going to have to report. And then any entities created on or after January 1st, you have 90 days to report from either the date that you received actual notice that the entity was created, or the Secretary of State's office that you filed in oh yeah, I just heard the big thunder boomies, provides public notice that you've been created. So if I can go online and see that you just signed up your LLC, you got 90 days from that date. Now, this is where it really starts to get tricky. Any entity created after January 1st, 2025, you have 30 days, not 90. You have 30 days. Starting in 2025, you've got 30 days to report. All right. Same rules. When 30 days from when? From when you first created it and became effective, or when the Secretary of State's office posted that you're live. 30 days. FinCEN has acknowledged that an extension may be considered, but otherwise, these are the final rules. Okay. Now, I'm not going to get into this conversation on this about any updated or corrected reports. Do it right the first time. You won't have to worry about it. But applicants, understanding who has to report and what they have to report is very important. So let me just see here. Now, let's talk about the entity that we call the reporting company. That would be a corporation, a limited liability company, or any entity that was created by filing a document with the Secretary of State's office. And then there are those entities that are exempt. And now the problem with this, and I'm not going to go through all of them, but you can go online, you can Google it. What you'd be Googling is exempt from definition of a reporting company for interest of the Corporate Transparency Act. Okay. Now let me just give you some ideas. Large companies are excluded. Banks are excluded. Issuers registered with the Securities and Exchange. I think that would mean any type of 506B, 506C registered entity. They would not have to register. Insurance companies, accounting firms, utilities, inactive companies. Inactive companies is something you need to understand, because I know a lot of people have been in real estate for a while. They've created companies for years and they've just kind of let them go by the wayside. Inactive companies are companies that are in existence on or before January 1st of 2020. They have not been engaged in any active business. They have not experienced a change of ownership in the last 12 months. They have not sent or received funds greater than $1,000 in the last 12 months. And they currently do not hold any kind or type of assets. If you've got one of those and it hits all of those 5 bullets, that's considered an inactive company. You don't have to report it. All right. Now, once you decided if you are a reporting company and you're not exempt, what do you have to report? Your full legal name, including any DBAs, and make sure you use the same name that you used on the formation documents. Don't try to change anything about that, because that's what they look for. They're very strict. The business street address, so it's a principal place of business. You need that address. Do not use a PO box. That does not work, or the address of any corporate agent or registered agent that you've hired. You have to use your business address. You've got to include, those are the 3, the jurisdiction of the formation, and then the IRS tax ID number. Okay? Are you a reporting entity? What do you have to report? Now, here's another type of entity that was created by the CTA and has its own definition. Applicant. Charlie, what does that mean? Well, yes, I know it's a very simple thing, but this is really important, is the applicant. The applicant who files and does the report for you and determines who the beneficial owner is. The answer is the applicant. Well, can I be the applicant? Yeah, you can. Oh, can I have a lawyer do it? Yes, you can. So let's talk about who can be applicants in this. Any individual who directly files the document that creates the domestic reporting company, attorneys, or similar third-party service providers, or the owner of the company, or an employee of the company, those are the individuals who are the applicants. They only need to file with respect to reporting companies formed after January 1st, 2024. All right. So this is starting up, that the applicants get involved January 1st, 2024. Applicant information does not need to be updated. Now, I'm going to talk about updating this information in a moment. This is going to be very, very important that you understand. So when the applicant files on and signs on as the applicant, they have to include their legal name, their date of birth, their business street address, and any ID number from a state issued ID, including a picture ID. So you have to have, if you're going to be the applicant, you've got to have your ID, passport, state driver's license in a PDF scanned in version, ready to upload, because they have that spot in there where you can actually do this. Now, the third type of entity that we're talking about in this CTA information is going to be, first off, the reporting, the applicant, and now this one, the beneficial owners. Now, this is where it gets tricky. Not really. You just have to read the rules and read the law. Any individual, beneficial owner is any individual who directly or indirectly either exercises substantial control over the entity or owns or controls at least 25% of the ownership interests of the entity. the expectation is that every reporting company will have at least one beneficial owner. Now, you might think to yourself, well, wait a minute, Charlie. My partnership has 10 people. None of us own 25%. Yeah, but there's somebody in there who has substantial control. And actually, it could be all 10. And then all of them would have to be reported as beneficial owners. All right, keep that in mind. They're really keeping this thing as wide open as they possibly can because they want to capture everybody. All right, so there was a time when people would think, well, what if I put it in a trust? What if trusts don't have to be disclosed? Listen, they got that covered in here too. So if you're trying to pull that, go figure out, go talk to an attorney, make sure you're doing it correctly, because chances are they're gonna find some reason to come after you. Don't be that guy. All right, another big thunder boomy. Substantial control. What does substantial control mean? So let me tell you a little bit about the indicators of substantial control, which include things like a senior officer of a reporting company, the corporate secretary, the treasurer, the corporate secretary and the treasurer are excluded from the definition of senior officer, but general counsel is included in that definition. And then authority over the appointment, the substantial control is somebody that has the authority over the appointment or removal of any senior officer of a company or a majority of the board of directors of a reporting company. All right. I can sit here and I can read through all the different types of exceptions there are or how they define substantial control. We're going to start doing this for our clients. Our law firm's going to start doing this for all of our clients. So we're gonna go through this. I'm not going to read it all here. I'll bore you all to tears. And then talking about the ownership or the control of the ownership interest. One of the things, if the plan is to leave your interests to your kids, they don't have to file until you transfer ownership through death or any other type of device. And death is a device to transfer ownership. Now, let me just see. Minor children are going to be excluded from that. What do you have to report for the beneficial owner? Legal name, date of birth, business street address, and then the ID number. Okay? Now, the reporting companies, the beneficial owners, and the applicants all may apply for a FinCEN identifier, okay? That may be provided in lieu of your personal details. Now, let me tell you the benefit to doing this way. And when you go on the FinCEN website and you start putting it in, it's going to ask you for that FinCEN identifier number. Now, that FinCEN identifier number is great because you only have to change your data once. See, anytime, like if you used a driver's license as your identifier, anytime your driver's license expired and you got a new one, you have to upload the new one to FinCEN for any reporting company that you're representing. And anytime you're an applicant, and if you're a beneficial owner, you've got to update that information. Can you imagine? I mean, if you got 20 companies. And you got to do that for all 20 companies when your driver's license expires, or you can get a FinCEN identifier, put it in once. When it expires, your driver's license, you can go in there and change the driver's license, and it changes all 20 companies automatically. So think about getting a FinCEN identifier. For those of you that have done TSA pre-check, it's the exact same process, just a different entity within the government that you're going to get your identifier from. So what if I don't? What if I decide I'm not going to do any of this? Well, God, they just they're always picking your pocket. They're always threatening you with life, liberty, and the pursuit of happiness. Civil penalties of not more than $500 for each day that the violation continues. Oh my gosh. Can you imagine? A fine of up to $10,000, imprisonment for up to 2 years, Or if they're feeling generous, they'll do both a fine and a penalty, a fine and an imprisonment. So just do it. Don't be that sovereign citizen kind of guy. Just go, crack it open and make sure you don't ruin your businesses. So let's see. That is, and you're going to ask yourself the question, well, who gets all this information? Well, okay, federal agencies, any federal agencies engaged in national security, intelligence, or law enforcement, state and local law enforcement agencies, only if it's court authorized, by request of a federal agency on behalf of a foreign authority. Like if you've been doing stuff up in Canada and they want to see it, well, that could happen as well. Any banks will come looking for you through this. Any financial federal regulators, that's how it works. You're just going to have to do it. You suck it up. It's going to become after October 1st. That's when there's going to be the big push to get all of this stuff done. So make sure that you get in there and you tie it all together and you do your job right, and you just comply. Just make sure you do what you're supposed to do and you'll be fine. That is what you're going to have to take into consideration. My firm, we're right now, we're working on making it so that my clients and my students can go right onto our website and register, and we're tied in to the Department of Treasury. The other thing is we're going to, I've seen, $99 if you want to hire a law firm, $250. I know, what's his name? Garrett Sutton was $250. We can do it. You can do it. Whenever you have us do it, you're shifting liability onto us. Obviously, that's one of the ways of protecting it. So these are some of the things you want to think about as you go through and complete your compliance. I want to make it easy for my clients so that they can not have to worry about this stuff, and that our firm will help walk them through the entire process. Okay. I'll tell you more about it once we become live with the Treasury Department's website. Also, I want to remind people that there are only a few spaces left, and I'm not kidding. I had a great conversation with the folks at Crexy today. I've been giving this thing away at a great deal. I said the top 25. We already have 25. I'm going to extend it for people that can get in with the 30-day free look. First month free. But after that, it's going to be get Crexy access through the Dobens Law license. We have a master license, and we're allowed to sign up people into Crexy at a reduced rate. I mean, typically they require a 12-month requirement. We're doing a 6-month requirement. They don't do first month free. We're doing the first month free. Test it out. We're going to help you understand how the system works. I'm going to teach you how to use it, how to find deals. And that's all through our membership. Go ahead. If you're interested, here's what I need you to do. Click on this link, fill out the form, get on the list. And I think the actual sign up get your credit card ready will be by the end of this week, probably more like the beginning of next week. And then the first 25 people get that original deal, which you'll see when you click on this registration. But then after that, we're still discounted over what Crexy is offering. If you go retail to Crexy, you'll be paying more and getting less of a deal. You'll have to sign up for 12 months. So it's really a great deal through the size that we are. We're able to do it for a discounted rate. It's awesome. I'm so thankful. We had a great relationship with Crexy. And if you don't know how Crexy works or why it's better, and I know all of these services. Folks, I was working with Pierce Island. Some of you don't even know what that is. Well, that was like the precursor to Crexi, precursor to CoStar. All right. And nothing is like Crexi. With the amount of data you can get from them, it is a gold mine. And if you're in this business, you need these types of tools. You might as well get it at a discount and get access to my services to teach you how to use it. So, all right, that's great. That is awesome. That's all I got today. 3:30, right on the money, right on the money. And then for those of you clients of mine, I will see you at 4 o'clock. And anyone else, I'll see you next Tuesday, 3 p.m. I think there's going to be a big shakeup in the Arbor Financial and all the other stuff that's going on. There was a great article that I'll go through on Tuesday regarding a multifamily investor who sued Fannie Mae and said, "No, you're not foreclosing on these properties. You have not done your due diligence. You're denying me denying me due process and equal protection under the law, and I'm suing you." And the judge agreed with him through the injunction process, not a final judicial decision, but through the injunction process. He enjoined Fannie Mae from foreclosing, and we'll talk about that on Tuesday. So, all right, everybody, great to see you all, and let's chat later. Always a pleasure. See ya.